Welcome back, everybody. My name is Tom Olsen. The name of the show is Olsen on Law, every Saturday morning at 11 right here on News 96.5. My guest today is attorney Rob Solomon. We are strictly discussing the George Zimmerman trial and what's been going on this past weekend so far. We invite your questions or comments to call us here in the studio at 407-297-9696. So, Rob, let's talk about what George Zimmerman has been charged with, which is second-degree murder.
Right.
The state attorney made that choice, and we don't really know fully why. I'm sure there are some politics involved in it, possibly. But define for us the four statutes what a second-degree murder is.
So a second-degree murder is a killing, first of all, that involves, that is, the perpetrator knew that it was what he was doing was imminently dangerous, and was done with with demonstration of a depraved mind without regard for human life. And so you don't have to have planned the killing. You simply have needed to do the act. And at the time you have done the act, you had to have this depraved state of mind.
And any examples of something like that?
Yeah, there are actually ones that might be not totally close to this one, but one of the more famous ones involves a man who was on a mission to rid the town of what he perceived as illegal immigrants, Mexicans in this case. Went out with a bunch of his buddies and fired into a trailer, which he believed to be the home of an illegal immigrant. He didn't know. He knew somebody was in there, but he wasn't aiming at anybody in particular. Killed somebody. That's a depraved mind.
Okay. So a lot of criminal defense attorneys out there, maybe you included, are saying, hey, there's no way that George Zimmerman can be convicted of second-degree murder. What a lot of people may not realize at this moment in time is that there are some lesser charges that could now be brought against him as part of the same trial. So tell us about lesser charges.
Okay, so in this case, a necessary lesser charge. There are degrees of lesser charges, different types, and one of the ones is what's called a Category A lesser included offense. That's an offense that essentially the judge does have to charge so long as one side asks for it. We can talk about which side might want to do that and the strategy behind that. But that charge would be manslaughter. Now, manslaughter differs from second-degree murder in that this depraved state of mind is substituted for, more or less, by recklessness, wantonness, what's called culpable negligence. And when you look for the definition of that, you see words like wanton, careless, without regard for human life. So it's a little bit different. You don't have to walk into this situation already being angry, evil, with evil intent. You just have to be greatly reckless.
Gotcha. Well, that makes, in a sense, perfect sense for this trial. So the question is, will the jury definitely hear, hey, you can convict him of manslaughter instead of second-degree murder, or maybe they're given that option?
They'll be given the option. I don't know if any of you noticed it, but when the defense moved for a judgment of acquittal, which was almost every defense lawyer will do at the end of the case, one of the things the state said in return is they gave a lengthy reason why that shouldn't be done. But at the end of that lengthy reason, in essentially 2 sentences, the state said, oh, by the way, Judge, if you were to agree with the defense in this case and were inclined to grant a judgment of acquittal, then you must charge manslaughter. And they did it in a sentence just to cover it, just to make sure that it had been heard by the judge. And they are on the record as having made the request for the manslaughter charge.
And are you indicating to me that the defense may argue against and say, Judge, we do not agree that you charge him with manslaughter?
Right. Well, it's going to be hard in this case because this is a type of a lesser included that generally they must charge. But I will tell you this. When you get to the point, which is the key element in this case, I think, it's always been that the charging of lesser includeds will be a pivotal moment that will be heard. Lesser includeds are asked for by parties who have different strategies. If you are winning the case in your mind, you probably don't want the lesser included charged. If you're losing the case, if you think that, then you probably want the lesser included charge. In my opinion, without prejudicing it, I think the likely party that's going to ask for it, and in fact has already in effect asked for it, is the state. I'm not saying they're losing the case, but in their mind they may feel that risk is there, and they certainly want a fallback position onto manslaughter.
Very good.